right, apparently I've been sitting here talking to myself for a while. Might start both my audio and my video. That might help. I might get a better response. Okay, folks, we are on the record in the 13th Judicial District, the District Court of Greenwood, County, Kansas. This is our 1:30 Friday, August 15th, preliminary hearing control document. All right, now I lost my place. We took up John Baker, and
Baker hasn't been taken up. We called his name, but he wasn't in the seat, so now he's in the seat.
Yep.
Oh, all right. Now we're ready on John Baker. On the record in 2025 CR 85, State of Kansas versus John Timothy Baker, Jill Gillette, County Attorney for the state, and Attorney Jorge De Hoyos for Mr. John Baker. Announcements.
So, Judge, two things here. We need to set this one for evidence at this time, and I do want to move for bond on Mr. Baker. I know that I made Jill aware of that earlier today.
Okay. All right. So what do we have for our evidentiary hearing then, Kim?
We have September 16th at 9 o'clock.
Counsel, does that work?
Just a second, ma'am. September 16th at 9 o'clock. Yes, ma'am.
All right, that will be the order of the court that the defendant counsel reappear, state be ready to go with its evidence September 16th at 9 a.m.
Now, Mr. Baker, I'll be on the phone with you shortly to talk more about that as early part of next week.
Sure.
All right, Mr. De Hoyos, I show that on June 10th at 25, his bonds was reduced to $10,000 cash or surety, no contact with co-defendant, and not to leave the state. And you're wanting to be heard again on that matter?
If I may, Your Honor.
Go ahead.
So, Judge, it wouldn't matter if the bond was $1 or $1 million. If you don't have a penny, you don't have a penny. You don't make money sitting in the jail. So what Mr. Baker has done is he has gotten a sober living environment together. It's at 204 South Osage. It's a 3 to 6 month commitment. He can go to, I spoke to the president of that organization yesterday. That is a gentleman named Nicholas Tanner, who confirmed that there is a home available for him, that he does have a sober living environment and opportunity. And I believe Mr. Baker's even found himself a job. I think that there's a lot of good things here that you could consider for Mr. Baker's release, and I'd ask that you consider the same.
You're recommending what kind of release? An OR or
well, Judge, because he doesn't have $1 to his name, it would have to be an owner cognizance bond to have any kind of effect.
All right, Ms. Gillette?
Judge, I prefer a cash surety bond. When he was here, we lowered him to 10,000. He keeps claiming that he hasn't been in trouble since 2010. However, he's been in trouble since 2010. In fact, he was convicted of robbery in 2017. And he's been in the El Dorado Correctional Facility in between there. In 2020, he was charged and he was convicted in 2021. So he's had lots of contact with law enforcement. And a lot of those are violent crimes. Robbery is a violent crime. He's also had failures to appear in 2021. He's had failures to appear in 2022. He's had failures to appear continually. We kind of went over this before, and that he wasn't to leave state and no contact with his co-defendant. But it just seems to be a string of cases and issues. He had failure to appear in 2022. So he's then gone to KDOC in 2024. So I believe that Mr. Baker is best served to keep a 10,000 cash or surety bond.
Mr. De Hoyos, your client is waving his head back and forth quite fiercely there. Do you want to respond to the comments the state has made?
Yeah, Judge, at the end of the day, I think Mr. Baker would dispute many of the aspects that were alleged there by the state. And to get those exact details, you'd have to ask him. And I'm I'll give you permission to do that if that's necessary. But Judge, I cannot fix the gentleman's past. What I can do is do my best to structure a future in which we can trust that the community is not threatened by his presence or any of his choices because he has a structured living environment of people trying to take care of him for his own good. That's what he got. That's what we have the opportunity for. That's an employment opportunity waiting for him. If you want to make him a model citizen, you got to give him a chance.
Well, Mr. Baker, what's it going to cost to get a bed in that facility?
I spoke with the guy, and like I said, I don't have a dollar, but everything my lawyer said, I trust, I agree with, and that's what I'm trying to do. I mean, I know I've had a bad past, but if I keep hanging on to that and keep living in that bad past that keeps being brought up, I can't get nowhere. And I mean, I'm gonna try, but I mean, it just starts with the steps that I've made so far, and that's all I have. And I'm
Well,
gonna
would you
try.
answer?
I'm gonna
Sure.
try. I'm getting older, and it's time for me to grow up.
Well, I'm not going to argue with you there, but I am going to ask you to answer my question, which is, what's that bed going to cost you at that sober living?
I'm not sure. I'm sure I'll have to pay rent. It's. I think it's. I don't know. We didn't go over that, but he agreed that he would help me get. He's got me a job and everything. So we haven't discussed the finances there. I'm sure it's probably what rent would cost, and same thing as it's a halfway. It's like a sober living house. So I'm not. I've
I know
never
what it
been.
is. I know
You've
what it
answered the
is.
question, Mr. Baker.
Okay.
All right. So in other words, you have no idea how much the bed costs, so you don't know if you've got the money to get in or not.
Oh no, he agreed that he would get me in, and he's got me a job, and he would take it out of my check. So
What's your job?
it's going to be working at the hamburger place over here.
You're in Eureka.
Yes, sir. Yes, ma'am.
So is this really a sober living house, or is this are you telling me that the gentleman at the hamburger place that helps people with records, are you calling him,
So,
people keep calling him a sober living
His
house,
name
and
is
I
Dan.
asked Dan,
No,
yeah,
this is a different guy. It's a
no,
different
I know
guy.
Dan.
Okay.
He owns Lomar. And
Yes,
I
ma'am.
asked him a while back, I said, why do these guys in jail keep telling me that you're running a sober living house over here
No,
or a
no,
halfway?
no.
He
There's a
said, no, I'm
misunderstanding.
not.
hey,
It's a
stop talking.
misunderstanding.
Mr. Baker, it's not your turn to talk. Please let the judge continue speaking.
Okay.
So anyway, Dan, I can't think of his last name, but I know him, who he is from when he was in your shoes and to when he got his life turned around and what he's doing now. But he says it's not a sober living, but he does try to help people as much as he can to reform, and I applaud him for that. But I don't want anybody misleading me or themselves to think that that's sober living.
So,
I
Your
guess
Honor, if I may,
go ahead.
Judge, I was skeptical when I first heard about this too. I don't know much about Eureka. I've driven into this city all of 2 times in my life. I'm very grateful to have the opportunity to practice in your fine courtroom. That being said, Judge, I am skeptical too. So I called Nicholas Tanner, and I invite you to call him yourself, 620-583-2168. I called him and I said, look, I need to know this is legit because I'm not going to put my clients in a place where they can fail. And he said, no, no, I've got a place for him. It's a sober living. It used to be a women's shelter. Now it's a men's shelter. It's called Amends The Chosen House at 204 South Osage Street. And I said, this sounds too good to be true. He goes, I'm trying to help people out. I said, yeah, I've heard that before, but you better be willing to take a call from court-related personnel about the same. So I invite you, Judge, to make a decision in 24 hours after you reach out to Mr. Tanner. But nonetheless, I do think the opportunity my client is speaking to is legitimate.
All right, so we've got two different names banding around here. We've got Mr. Tanner and a safe house over in Wichita, and we've got Dan that runs the hamburger joint here in town. Somehow, this defendant is going to get back and forth regularly from the house in Wichita to the job in Eureka. I don't see that being practical at all. I don't see that happening. But I'm going to deny the request for bond modification at this time. But with more information, I would certainly reconsider what you're suggesting.
I'll work
And
with Mr. Baker on the same.
all right, thank you very much. So at this time, bond request or modification is denied. Your preliminary hearing is September 16th at 9 a.m. You must be back here at that time, sir. And we'll be in recess. Mr. Baker is remanded to the custody of the sheriff. Aaron Dye, are you here? Is Aaron Dye in custody? Aaron Wilbur Dye?
He's in
You've got
custody.
him?
Thank-
Okay. All right, we're on the record in 2025 CR 102, State of Kansas versus Aaron Wilbur Dye. Jill Gillette, County Attorney for the state, Attorney Jorge De Hoyos for the defendant, who also appears in person in custody. Mr. De Hoyos, any announcements concerning this matter?
Judge, can I get that 1010 docket? Mr. Dye made me aware of a new case that's being filed against him in Greenwood 25 CR 130. Speaking with Jill, it's going to be best that we put these, excuse me, Miss Gillette, it'd be best that we put these together and do something global on this. And I think Mr. Dye anticipated the same.
What's going on 1010? Is that a preliminary hearing in the other case or just like a first appearance?
That's the 1010 prelim hearing control you said on Chris Regier and Michael Smith.
All
Judge,
right,
he's scheduled for a first appear on his new case.
all
And
right, so we could maybe put the new case on the same docket of 1010 with this one.
That would be great.
All right, this matter will be set for preliminary hearing control October 10th at 1:30. Mr. Dye, you must be back here at that time with your counsel, ready to go. And you have not made bond yet, it looks like. You've been ordered to be held without bond. You have some serious drug charges, numerous ones against you.
Judge, I had down that you said he met 40,000 at his first appearance. No contact with co-defendant or witnesses.
That is what I said. Is there any reason why I shouldn't continue with that?
No, I will just ask that same bond to continue on this matter.
And
Yeah,
that's
Judge,
what-
I don't think I have anything we can do here because the new bond's going to be a part of that matter too. But 1010 for both will give me the opportunity to work with Jill to get this, excuse me, again, Miss Gillette to get this thing resolved right.
All right, if we need to take up bond, we can take it up again at that time, but at this point, I'm not inclined to modify it. Okay, but I will remand the defendant, Mr. Dye, to the custody of the sheriff at this time.
Thank you, Honor.
You're welcome, thank you. We'll now take up Alfred Galindo on the record in 2025 CR 89, State of Kansas versus Alfred Luis Galindo. County Attorney Jill Gillette for the state, Mr. De Hoyos for the defendant. Alfred Galindo.
You there, Mr. Galindo?
Yes, I'm here.
We're
Yeah,
looking
I'm here.
criminal threat, assault of a law enforcement officer, possession of marijuana, paraphernalia with intent to use. That's the misdemeanor. We have, I guess the only felony is count one, the criminal threat, Mr. De Hoya.
Judge, the parties have reached an agreement whereby Mr. Galindo will plead guilty to a misdemeanor, and we'd like to move forward with go ahead and moving to sentencing and disposition of the matter.
You're wanting to move to misdemeanor threat today, Ms. Gillette?
Yes, Judge.
What would that be? Is there a misdemeanor threat or assault?
I think it's misdemeanor assault. Is that right?
I didn't know there was one. I thought it was criminal threat. I don't recall a misdemeanor threat, but maybe there is.
There isn't
Uh,
a criminal threat.
So it's an assault, which
Yeah.
is kind of the same thing as a misdemeanor threat, sort of.
Yeah, right.
What's the statutory number on assault, Ms. Gillette? The penalty's a lot less probably than what it would be, but
It's 215412.
and is the state moving to amend that to 215412?
We are, Your Honor.
Knowingly placing another person in reasonable apprehension of immediate bodily harm, subsection A.
Yes.
Okay. All right. And how does your client wish to plead to that misdemeanor charge, Mr. De Hoya?
Sure, Your Honor, it'd be a no contest plea at this time.
All right. Mr. Galindo, you are not in custody, are you?
Am I not there?
There you
Mayor.
are. No, I just want to make sure I knew which one you were. All right, so Mr. Galindo you're not in custody anywhere, are you?
No, ma'am.
You're on bond?
I'm on bond.
All right.
I'm actually staying at the house you were referring to earlier about
So
Dan. Yeah,
you're
Lomar's.
You're standing with Dan down at the restaurant?
Yes, ma'am, and I'm working there as well.
Okay, all right. Okay, so Ms. Gillette, he has criminal threat causing terror, evacuation, or disruption, and that one I understand you're amending to 215412, misdemeanor assault. What about those other counts,
We'll be dismissing those, Your Honor.
including the assault of a law enforcement officer?
Yes.
Okay. All right, Mr. Galindo, how do you plead then to that amended count of violation of KSA 215412, assault, alleging that you did knowingly place another person in reasonable apprehension of immediate bodily harm in Greenwood County, Kansas?
No contest?
Okay, no contest. You're not admitting that you did it, but you don't want to deny it and take it to trial. Is that correct?
Correct.
And who did you make the comment to frighten? Was it this Melissa Bushnell that's mentioned in count one of the criminal threat?
I believe so.
Well, you need to know. If you don't know, I don't want you guessing.
Well,
Yes.
no contest lets me give the proffer.
Oh, I'm sorry. No contest. Thank you. Yes, it does. By no contest, you're not admitting or denying, so I shouldn't be asking you that question. I'll take that back. I'll take that back, and any answer you have had, I'll disregard. Okay.
Judge, officers responded to a call that he was out of control and drinking. The girls had again taken some alcohol from him. He was pretty angry, yelling at everyone, out of control, making threats, swinging around. He was very intoxicated, made her in fear of bodily harm due to his actions of swinging and being out of control. And he also admitted that he had been making threats and stating that he wanted to kill his son and his son's girlfriend and the landlord. So he ended up being taken out of the home in handcuffs.
Well, according to Deputy Fisher's affidavit, this was a private home in Eureka, Greenwood County, Kansas.
Yes, he was with the landlord was also around at that time, out and on throughout the day.
All right. And is Melissa Bushnell the girlfriend of his son, or how does she play into this?
His girlfriend?
It's Mr. Galindo's girlfriend?
Yes.
All right. All right. Well, I find based on the proffer of what the evidence would show if this were to go to trial, that there is a factual basis to support a no contest plea and to find the defendant guilty, and I do find him guilty of the amended charge of assault, KSA 21-5412, parenthesis A.
Judge, we're going to recommend 30 days underlying with probation. This is going to be our first stepping up probation. So we'll ask that he sign a release for the CSO to talk with Crosswinds. And he will continue. He has had a drug and alcohol evaluation already. So it's going to be recommended he follow those and that he comply with the stepping up program for counseling to treat the underlying conditions as to why he's drinking, try to help him repair his relationship with his family, and hopefully have the mental health and drug and alcohol treatment to help him not have to come back here. I wish him the best in that program, and I hope that it's successful for him. We'd ask out at 12 months, and if he gets done sooner with the stepping up program with successful discharge, then his CSO can bring it back before the court.
All right, you're not asking for a fine?
I am not, because I don't know if he'll have any cost of his alcohol treatment,
Hmm.
because he's already paid for his drug and alcohol evaluation. Um, he
Right.
he's our first stepping up candidate.
And that's basically what a combination of mental health and drug abuse therapy, drug and alcohol.
This case, alcohol. He'll
All
work.
right.
He'll work with Crosswinds and his CSO.
All right. And Mr. DeHoyas, anything further before I pronounce sentence?
No, Judge, I would concur with the recommendation. I think Mr. Galindo understands he's too old to keep being a frequent flyer in this court and with Peyton Paul. So we hope he gets sober too, enjoys his time being a boyfriend, a husband, and a dad. But get sober or just stay in jail.
There you go. All right, Mr. Galindo, at this time, I'm not going to order a fine, but you are going to be responsible for $158 of court costs, $45 booking fee. Mr. DeHoyas, are you appointed or retained?
I'm appointed.
I'm going to order $250 appointed attorney fees, since you said you are working down there at the restaurant. Is that right?
I am working. I'm only getting about 12 hours a week. And I have to, from those 12 hours, I'm paying for the rent for my staying of here. So,
All right. Well, that's what I'm going to put you at. And I'm going to let you and your court service officer decide how much you can afford to pay per month. But I want monthly payments. And your first payment is going to be due September 15th. And like I said, they'll determine how much you need to make per month.
okay.
And
Because
you're going to have
I'm
what's
also on
that?
the disability, and I'm paying the fine that I have in city court, which I paid this month, and I have to see you on Monday for that.
All right. Well, we'll talk about that in city court.
Okay. And as far as the no contact order,
This is your son's girlfriend? Is that who we're
no,
talking
no,
about?
no, no, no. I can see in the
That's your
photo, I can see in
girlfriend?
the screen, that's my girlfriend.
She's here.
Oh, the victim is here on the Greenwood County Courthouse screen. Do
Yeah.
you want to be
Yes.
heard on this, ma'am?
Yes, I do. Please,
What's your
Your
name?
Honor.
What's your name?
Melissa Bushnell.
And what do you want the court to consider, Miss Bushnell?
I would like to have a no contact order dismissed. When I called the police, I believe he was in a blackout. He was just drinking for days. I don't think he realized what he was doing, and I was very scared. I did not lie about what he said, but I don't think he knew what he was saying. I really need him in my life, Your Honor. Please.
Well, Miss Bushnell, the problem I have is that without some kind of intervention, you could end up in that very same position in a day or two, or a week from now, a month from now. So I can't just send him back to that same situation without having him get some treatment first, and then having the treatment provider maybe even talk to you or have you get some therapy and decide if you're going to be safe together or not.
What,
Because
Miss,
I can tell you, it's not unusual to have things blow over and then everybody want to get back together again just to watch it happen again down the road.
I have
Right.
a safety plan in place in
With
case
whom?
that I have a safety plan in place. I've been sober for 3 months. There's no drinking or I don't do that no more. And I think that was our major problem is that
And you were drinking as well on June 8th of 2025 when this
I
happened?
was not, no. I was
And-
not drinking.
Okay, well, what I want is for him to get, and I'm ordering for him to get, a drug and alcohol evaluation and mental health therapy. And if he can do it through this Crosswind Stepping Up program, excellent. But he's ordered to do that. You're ordered to have
Judge?
No alcohol and drugs, Mr. Galindo. No alcohol and drugs. Maintain your employment. What is it you're wanting to say, sir?
I did a drug and alcohol evaluation already,
Then
and it came,
all
and
right.
you got the results back. And I am
Alright.
currently going to Crosswinds seek with I have therapy with Lauren. I go every other week.
So,
In fact,
Mr.
I have one
Galindo,
on the 3rd of next month.
Mr. Galindo, just demonstrate that to your probation officer, and they'll work with you through the stepping up program to make sure what you're already doing is not being repetitive, not being repeated, and they'll take care of all these things. But the judge right now wants to make sure that the record is clear what she expects of you, whether you've already done that or need to do that.
That's exactly right.
I believe I have to. I'm
Now
sorry.
listen, slow down. Now sign any
Okay.
releases court services and stepping up needs you to sign so that, as Ms. Gillette said earlier, they can make sure, and as your counsel just said, sign the releases so they can see you're doing what you're ordered to do. And,
Yeah, I understand. I understand that. I agree.
and I'm going to continue with no contact with your girlfriend until if she wants to have contact with you. I can't order her to do stuff because she's not the defendant, you are. But if she wants to have contact with you, the two of you need to be able to show each other's therapist what you've done so that the therapist can make recommendations to probation and back to the court when you two are ready to have contact. Because I don't need either one of you drinking or fighting because we know where that leads you. Somebody's going to end up maybe hurt and definitely in jail. So that's what my order is. You can have contact when your therapists say you're both ready.
Okay, now I'm supposed to meet with them on when? Monday?
You're supposed to meet with I don't know what your appointment is with the therapy, but whatever it is, you have to keep it. I am ordering that you contact probation as soon as you're released.
I'm not in custody.
No, right after the call.
Contact them. I keep seeing that brick wall, and I'm familiar with some facilities that have that. Contact them as soon as you're released from this hearing, sir. And
Yes, ma'am. Yes, ma'am. I will if I can speak to Hoyos to get a number.
Hey,
Well,
Mr. Galindo, we'll take care of that.
I can tell you right now, probation, that you call their general number for the district, which is 316-322-4153, and they will fix you up with your probation officer. But call them as soon as you're released from this hearing, and I'm just ready to release you. Anything else from anyone?
No.
All right, then, Mr. Galindo, good luck on your probation. Call probation right now and follow their directions.
Thank you.
You're welcome. And don't go out and celebrate with the girlfriend, not yet.
Yes, ma'am.
Okay, we'll be in recess for your probation.
Wherever you're at, Judge, I've got 10 minutes. So I got to drive, but I'm with you.
Oh,
I'm yours.
okay. We do Michael Ray Smith. Did we ever get him?
Yeah, we're good.
Okay. And we're through with yours. So then are we going to go back and do Mr. Pa's cases?
Yes, ma'am.
Okay, let's keep busy on those. On the record in 25 CR 50 State versus Amanda K. Cortez, Jill Gillette, County Attorney for the state, Jorge De Hoyos for Richard Pa, and for the defendant who also appears in person. How does she wish to proceed?
So, Judge, in this matter, we received an offer for the count one, which would make her Senate bill eligible. And so, in a perfect world today, we would enter a plea to count one, unlawful possession of a drug for Senate bill. But
All right,
I
but
have
that's the
not
felony,
had a chance to clear that with Ms. Cortez yet.
and that would need to go before the district judge that's going to be sentencing her anyway, I do believe. So I'm here just on the issue of prelim. Does she want to set a preliminary hearing control? Does she want to waive it? Does she want an evidentiary hearing?
So, Judge, Ms. Cortez, do you have a position?
I don't. I haven't talked to anybody yet.
I think we better set this over for the next available
Yeah.
PHC. When's our next available one, Kim?
October 10th at 1:30.
Does that work, Mr. De Hoyos?
It works fine for me. Miss Cortez, before you go, make sure I got your new phone number.
It's the same number, 316-519-4415.
Oh, stop.
Thank you, ma'am. Yeah, that's fine.
Don't want anybody else calling her that doesn't need to. You're on
That's right.
YouTube. You're on YouTube. You don't
Yeah.
need any. All right. Okay. If there's nothing further, Miss Cortez, who looks like she's in a moving car, don't do that to me again.
Okay,
All right. We are in recess.
thank you.
All right. Who is next on Mr.
Wherever you got,
Cox?
I'm down.
On the record in 25 CR 43, State of Kansas versus Shay Donovan Cox. County Attorney Jill Gillette for the state. Jorge De Hoyos for Shay Donovan Cox. Where's Shay Cox? There he is. Is Mr. Cox going to have a prelim or not? Or what have you decided?
Judge, this is one where I intend to waive the prelim here today. We did receive an offer that I anticipate is going to resolve the case, so I do need to speak to Shay directly about that, but it's for all those reasons I'm anticipating waiving the preliminary hearing today.
All right. Mr. Cox, have you talked to your attorney about waiving a preliminary hearing? I can't hear you. Can you unmute?
Sorry, yes, Your Honor.
And are you wanting to waive the prelim today?
Yes, Your Honor.
You said you've talked to your attorney, then you know that it's the felonies. Counts 1, 2, 3 that entitled you to a preliminary hearing, which is one in which the state has the burden of producing evidence to make it appear that each of these felony crimes has been committed and to show probable cause that you committed each of these. It is not a trial to determine whether you're guilty or not guilty. Rather, it's a hearing to determine if there's enough evidence to require you to stand, or in other words, be bound over for trial. And at the preliminary hearing, you have the right to be present with your attorney. You'd have the opportunity to challenge the state's evidence, to challenge the existence of probable cause for further detention, and in your case, for requiring further bond or bail as to the felony charges. You would have the right to subpoena witnesses, cross-examine the state's witnesses, and present evidence on your own behalf. A preliminary hearing would also apprise you about the nature of the crimes charged and the sort of evidence you'd be required to meet if you were to stand trial. If you waive or give up your right to preliminary hearing, there will be no hearing and you will be bound over to the district judge for further proceedings. You will be required to appear at a later date before the district judge for arraignment, at which time you will enter your plea to the charges against you. And until that time, you will continue to be released on your appearance bond and obligated to appear under the terms of that bond. Now, have you talked with your attorney about your right to waive this hearing?
Yes, Your Honor.
Do you need any more time to visit with your attorney before we proceed?
No, Your Honor.
Do you want to waive your right to preliminary hearing?
Yes, I want to waive my right to a preliminary hearing.
Are you voluntarily waiving this right?
Yes.
Has anyone made threats or promises to cause you to waive the preliminary hearing?
No, Your Honor.
And are you in good health today?
Yep.
Taking any medications which might impair your judgment today?
No, Your Honor.
Mr. De Hoyos, do you know of any reason why the court should not accept the defendant's waiver?
No, Your Honor.
And Ms. Gillette, the state waives its right to preliminary hearing?
The state, Honor.
Then the court finds the state of Kansas has waived its right to preliminary hearing. The court further finds the defendant has made a knowing waiver of his right to a preliminary hearing after consultation with counsel. Therefore, it is the order of the court that the defendant is bound over to the district judge for further proceedings. The defendant shall next appear before which judge and when, Kim?
Let's see. That will be with Judge Ricky on September 11th at 2:00.
9/11, September 11 at 2:00. You must reappear by Zoom, counsel and defendant, before Chief Judge Ricky for arraignment, at which time be ready to enter your pleas and set the matter for trial if necessary. All right. Anything further before I let Mr. Cox go?
Not from the defense.
All right. If there's nothing further, Mr. Cox is excused. You can contact your attorney if you have any other questions or concerns, sir.
Thank you, Your Honor.
Thank you. You are excused. Continuing your bond. Will be on the record in Blair Edmonson, 2025 CR 111, State of Kansas versus Blair Forbes Edmiston. County Attorney Jill Gillette for the state. Is Blair Edmiston here?
Yes, Your Honor.
You're there in custody. Mr.
Yes.
Edmiston appears in custody. And with counsel, Jorge De Horace on one count of rape. And Mr. De Hoyas, how does your client wish to proceed on preliminary hearing?
So, Judge, this is kind of a bigger case, and I had not had a chance to fix this with Mr. Edmondson before making the appearance today. So I'm going to ask you for one more continuance in the hopes that I'll be able to talk to him in the very near future.
How about if we continue this at the defendant's request to 10:10 at 1:30? And
No
if you
objection.
decide, if you want to get it on a docket earlier than that, of course, I'll just tell Missy that I want to get it where we can.
I'll back in touch with you next week, Mr. Edmondson. Thank you.
Thank you. You have a good day.
All right, thank you. You may go, sir.
Good pace. We got three more, Judge, and we're going to need to continue Whitney Haron. There's drug counts there that we're waiting on labs for.
All right, which one is that?
That's 25 CR 71. If you just want to push to 1010.
Is that the gentleman here?
No.
What's your name, sir, in the jail?
James McConkie.
I'm Teresa Whitney Haron.
Okay, we're on the record in 25 CR 70, State of Kansas versus James A. McConkie. That's one of Mr. Pa's cases. Jill Gillette for the state, Mr. De Hoyas for his partner, Mr. Pa. And how do we want to proceed on Mr. McConkie?
Judge, I have it in my notes. We intend to. Hey, Ms. Harrington, please mute your. Ms. Haron, rather, please mute your phone. On Mr. McConkie, I have it in here. We're waiving the prelim today. We've been made an offer. I need to communicate over there to Mr. McConkie.
Okay, Mr. McConkie, is that right? You want to waive your prelim today?
Yes, ma'am. Yes, Your Honor.
All right, you do have the right to prelim on each felony count. And as you've heard me say, the preliminary hearing is one in which the state of Kansas has the burden of producing evidence to make it appear that the felony crimes were committed and to show probable cause that you committed each felony. A preliminary hearing is not a trial to determine whether you're guilty or not guilty. Rather, it is a hearing to determine if there's enough evidence to require you to stand trial, or in other words, to be bound over for trial. At the preliminary hearing, you have the right to be present with your attorney, to challenge the state's evidence, to challenge the existence of probable cause and further detention. And you have the right to subpoena witnesses, cross-examine the state's witnesses, and present evidence on your own. At the preliminary hearing, the evidence would apprise you about the nature of the crimes charged and the sort of evidence you'd be required to meet if you were to stand trial. If you waive or give up your right to preliminary hearing, however, there will be no preliminary hearing, and you will be bound over to the district judge for further proceedings. You will be required to appear at a later date before the district judge for arraignment, at which time you will enter your plea to the felony and the misdemeanor charges. And until that time, you will be remanded to the custody of the sheriff until or unless you're able to make bond, and then you'd be obligated under the terms of that bond. Now, have you talked with your attorney about waiving your right to preliminary hearing?
Yes, ma'am. Yes, Your Honor.
Do you need to visit any more with your attorney before we proceed?
Not unless he says so. No, we're
All
good.
right. Okay. Do you want to waive your preliminary hearing at this time?
Yes, Your Honor.
Or are you voluntarily waiving this preliminary hearing?
Yes, Your Honor.
Is anyone making any threats or promises to cause you to waive?
No, Your Honor.
Are you in reasonably good health today?
Yes, Your Honor.
Are you taking any medications which might impair your judgment today?
No, Your Honor.
And you do wish to waive your preliminary hearing?
Yes, Your Honor.
Counsel, do you know of any reason why I should not accept the waiver?
I do not.
Ms. Gillette, does the state wish to waive its right to prelim?
State does, Your Honor.
The court finds the state of Kansas has waived its right to preliminary hearing. The court further finds the defendant has made a knowing waiver of his right to a preliminary hearing after consultation with counsel. Therefore, it is the order of the court. The defendant is bound over to the district judge for further proceedings, and the defendant shall next appear before the court for arraignment. And when will that be, please, Kim?
That would be before Judge Crum on September 4th at 9 a.m.
September 4th at 9 a.m., you are ordered to reappear before Judge Crum. Counsel, if that date doesn't work, you'll need to get with his assistant and reschedule that.
Yes, ma'am. Thank you.
Thank you. So, Mr. McConkie, that is the order of the court. And if you have any other questions or concerns, please feel free to contact your attorney who will address those.
Thank you, Your Honor.
You're welcome, and you're excused at this time, remanded to the sheriff. We'll now take up, didn't we take up Christopher Regier?
Yeah, we did. We are on Whitney Haron, who appears by Zoom.
We are on the record in 2025 CR 71, State of Kansas versus Teresa Whitney Haron, Jill Gillette for the state, and Mr. Jorge De Hoyos for the defendant. Are you here? Yes, you are. Ms. Teresa Whitney Haron
Yes.
also appears in person by Zoom. Counsel, your client's with some preliminary hearing.
Judge, I need this one continued. The parties have exchanged a little bit about it, but as I see it, I need to get down to that 10-10 date at 1:30, please.
Any objection, Ms. Gillette, to continuing this over to 10-10 at 1:30 for disposition?
No, Your Honor, we're waiting on blood.
All right, Ms. Whitney Haron, this matter is being continued at your request via your attorney, 10-10 at 1:30, at which time you'll either announce for prelim or waive the same, or possibly enter a plea if necessary or desirable. If there's nothing further, we'll be in recess. Ms. Whitney Haron is excused from today's proceedings. And Mr. De Hoyos, you have anyone else?
I've got Esther Lee Ramos.
All right. We're on the record in 2025 CR 61, State of Kansas versus Esther Lee Ramos. County Attorney Jill Gillette for the state. Mr. Jorge Ramos, no, Mr. Jorge De Hoyos for the defendant, who also appears in person in custody. Mr. De Hoyos, your client's position on this matter, prelim?
So, Judge, I have not yet cleared this with my client, but we did receive an offer just this afternoon that I think will end up resolving the case, but I do need to speak with the defendant about the same. They are in custody. I don't recall their criminal history, but if the state is interested in entertaining a bond motion, we can make that at this time.
Or we could just set this over to 10-10 at 1:30, and you could expedite it after you've had a chance to talk to your client, if you wish.
I could make that work, ma'am. Yeah, I think I could definitely make that work.
All right, let's do that. I'm going to continue this, Ms. Lepe Ramos, to 10-10 at 1:30. Between now and then, I'm expecting your attorney to get with you and talk to you about what the state is proposing and see if you want the evidentiary hearing and see if we need a bond reduction hearing or if maybe you can be released upon your agreement with the state. So if nothing further, I'm going to remand you to the custody of the sheriff. And as I said, expect your attorney to get with you very soon.
Judge,
Yes.
this is a large amount of marijuana, but she does not have prior criminal history. So I am willing to lower her bond, but I still prefer it be cash.
Yeah, let me grab some. Here you go, bro.
Well, I show her bond is set at 17.5. You're wanting to go lower than that?
I would be okay with 7,500.
Where are you from, Miss Lepe? Miss Ramos, where are you from? Where do you live?
I'm from Wichita, Kansas.
I thought this was the lady in jail, but now I've got somebody else showing up. Who's the lady in the jail?
Oh, she's out of custody. I was thinking she was the one in custody. Out.
Okay, well, you're not who I thought you were. The lady that just showed up on my screen. Are you Esther Lepe?
Yeah, I'm Esther Lepe.
Okay.
All right, who's the lady in the Greenwood County Jail that seemed to be answering to the same?
Brandy Mattis.
Haven't we
Oh,
already,
McConkie. The attorney McClellan or whatever his name was.
Yeah, McClellan, McClendon.
Clendon, that's it. Forgive me.
All right, well, I don't think we need to reduce bond. It looks like she's already made it, so. So I'm gonna talk to you, Miss Ramos. I was looking at the other lady, no wonder. Miss Ramos, you're gonna be ordered to come back 10:10 at 1:30, and your attorney will visit with you soon, but he needs to know where to get a hold of you. Have you given him all your contact information?
I had called him on my number. I don't know if
Ms.
he
Ramos,
still
I'll
has it.
try calling you early part of next week. If I can't get in touch with you, I have your address, so we'll make contact, okay?
Okay.
All right, thank you. Then Esther Lee Ramos, you are excused but ordered to reappear at that date and time.
At 10:10, right? You said?
That's right.
10:10 at 1:30.
Okay, thank you so much.
You're welcome. Mr. De Hoya, anyone else?
So, Judge, that ends my list of cases, but I got a question for you. Is that your red Corvette out in front of the county courthouse?
I'm not making any
Are you kidding me? That thing is awesome. That
I'm
thing
not
is
making
cool
any
as hell.
comments. I'm not making any comments.
Okay.
All right. Well,
Thank you, Judge.
I'm just throwing personal information out here right and left today, but I'm not addressing that.
No, Judge, thank you so much for making this quick. I appreciate it. Everybody have a great weekend.
All right. Well, you be careful out there.
Take
All
care.
right.
Yeah.
Now let's go back to the lady. Did Mr. McClendon ever indicate he's going to join us, or is he still tied up in the other court?
I have not heard from him, but we do have one pro se litigant. Last name Amaya.
I see that. Where is Emily Amaya? Are you here? Okay. All right, we'll take that up. I don't know how you got on this docket without an attorney, but we will take it up. We're on the record in 2025 CR 112, State of Kansas versus Emily Cheyenne Amaya. County Attorney Jill Gillette for the state. Emily Amaya appears in person and pro se on the preliminary hearing control docket for possession of opiate, opium, narcotic, or certain stimulant. And did you apply for an attorney, ma'am?
I did. So what happened was when I applied, after I applied, my phone completely broke. So I don't know. I couldn't get back into my other email. So I had to reapply for it. And so I just did that. I can show you my phone. It completely shattered. I couldn't get into my old email. And so I just applied for it again to see.
Well, I
And they
remember,
just, yeah, go ahead.
yesterday Missy gave me an application that said was for court today, and that might have been yours.
Yeah, I've tried multiple occasions to get back into my old email. It wasn't working, and I knew it was coming up, so I just kind of had to send it in.
Where do you work?
I work at Walmart.
All right, and what do you get paid per month?
Per month, I'm gonna say maybe 1,500. I think that's what I said last time.
Well, not what you said last time, but what do you actually make?
I make $14 an hour.
How many hours a week do you work?
40.
How long have you been there?
On the 20th will be a year of this month.
Okay. Well, I think that comes out to a little more than 1,500. Maybe you're talking about after taxes. What do you pay for rent or mortgage, if anything?
I've been couch hopping right now. So I was living with my sister until all that happened, and I was paying 400, and then I live with my mom, and
Right now you're not having to pay, or are you giving them something?
I was not at the moment. I'm not giving anyone nothing.
Okay. So what are you doing with your 1,500 a month or 2,240 or whatever you're making?
I'm paying my phone bill, and then I'm also paying my insurance, and when I come back to my sister's, I'll be paying back my 400.
All right, so what are you paying on your phone?
My phone bill, since I have my dad on it, it's like 2 something.
And your insurance?
And my insurance, it is 1 something, 150 maybe.
What kind of insurance is that?
I have no.
Is it,
No, it's a car insurance.
okay. All right. Well, you don't have any children by chance?
No, I do not.
I'm going to appoint attorney. What is this? It's felony.
Felony.
It's a felony, so I'm not sure who Missy's going to appoint. Call back next week, the middle of next week, and find out who your attorney's going to be.
Okay.
And
And-
then we'll give you a new court date. PHC will be, when's our next one?
10
Is it the
25.
10? You must be back here with that attorney 10:10 at 1:30. Make sure you talk to the attorney as
So
soon as you
at
get the name and
10:10?
contact. 10:10. That's October 10th at 1:30. You must
Okay,
be
and
back
then
here.
what's the phone number am I supposed to call?
All right. You call Missy at 620-583-8155.
Okay, thank you.
Okay, thank you.
Okay, and you said that 10:10 at 1:30?
Yes.
Okay, thank you so much.
Make sure you call your attorney when you find the name and number next week. All right,
Okay,
you're
I will.
excused.
Thank you.
Miss Amaya.
Mhm.
Well, I am going to take up the lady in the jail. Your name again, remind me, I'm sorry. Is it your Mattis? Brandy Mattis, right? We're back on the record in 2025 CR 126, State of Kansas versus Brandy Renee Mattis. Jill Gillette, County Attorney. Brandy Mattis still appearing in person in custody and still without counsel, Mr. McClendon, who's been appointed and is usually pretty diligent about attending, but I understand he's tied up with another judge in another court. So what I'm going to do, I'm going to have to continue this rather than make you sit there till who knows when, Miss Mattis. I understand our next hearing is not until 10:10 at 1:30. And rather than just have you sit there in the county jail, Ms. Gillette, can you let I will do the same, but if you'll let counsel know that his client is in jail and see if you two can work out something for an earlier setting.
I was going to say, Judge, if you wanted to do a special setting, I was trying to find a time he was going to be with us already.
That'd be fine. That'd be preferable.
Or that we were already meeting.
Right.
I know he's here that 9/12, but it's so overloaded right now. But she's in custody, so.
Right. Well, that's still about 60 days out. Do we have anything even sooner? Any misdemeanor dockets we could put her on?
9/12's like.
It's the earliest.
Not quite 30 days. It's like a day shy of 30 days, so 27 days. If we want to do that 9/12.
Okay. All right. Yeah, you're right. Let's do that. Okay. 9/12 at 1:30. We'll do that.
And if we can get in front of you sooner, we'll get in touch with Missy.
Yes, please do that. All right. I'll send a message to your attorney to get with you. And I will see you back here 9/12 at 1:30, if not before, Miss Mattis.
Thank you.
You're welcome. And you are remanded to the custody sheriff as well. And Kim, I think that concludes the docket. Is that what you showed?
I have one more.
East,
Oh, Westwood, is it Eastwood?
she's
Yes.
in you, same thing.
All right. All right, we're on the record in GW 2025 CR 124, State of Kansas versus Summer Dawn Eastwood, County Attorney Jill Gillette for the state. The defendant appears in person, in custody, but without her counsel, who appears to be running late in another court. And I'm going to do you, Miss Eastwood, like I did the Mr. McClendon's client right in front of you. Set this over to September 12th at 1:30. And then if he gets with you and we want to get that set up, I'll fit you in earlier, but I'll let him know that you're in the jail and you're available for him to see you. Does that work for you, Miss Eastwood?
Yes, may I get a bond reduction? I have some medical issues that really need tended to.
All right, let's look at that. Your bond is 10,000 cash or surety, and your charges include count one of unlawful possession of the controlled substance methamphetamine or MDMA, unlawful possession of the controlled substance marijuana or THC, and count 3 unlawful possession of drug paraphernalia and misdemeanor. Where are you from? Where do you live when you're not in custody?
I'm from Boone County, Arkansas, just on the Missouri state line.
Okay, Arkansas. You said Boone County?
Yes, it's right on the Missouri state line next to Hollister.
Okay. And Miss Gillette, your position?
Judge, we lowered her bond to 10,000 cash or surety before at her first appearance, and looking at her criminal history of what I know of, I think she's gonna be a third strike case for us here. And I know we set it at 10,000 cash or professional surety because she lives out of state, and bondsmen make sure that they make it here and don't run to another state. That's my big concern. And again, based on what I know her criminal history to be, this is a third strike case. I don't know what her medical conditions are, and I don't know that she wants to put those out on YouTube.
I have MS, and I was just diagnosed before I got arrested.
So I don't know if she has spoken with our jail staff. I haven't had any contact from the jail saying there's a big concern. But I can check into it, and then I can visit with Mr. McClendon about it.
Let's do that, and then if you want to bring that back up either later today or first thing Monday.
Okay, I can do that.
Well, first thing Monday is my Butler County docket. Fit it in there where you can. We'll take care of it. If you want to journalize something with Mr. McClendon, I would certainly entertain that upon notice.
Okay.
Yes, ma'am.
Yeah, and my jury trial's gone off for next week too, so I'll have some time with you maybe on Tuesday.
Okay.
All right, so that's where we are on your case, and if you don't hear from Mr. McClendon in a few days or next week, I'll be surprised, and you can let the jailer know to notify me that you still haven't heard from him, but give him a little bit of time to wrap up whatever he has going on this week and then to gear up for next week.
Okay, thank you so much.
Thank you. We'll be in recess at this time. You may go back to the sheriff's custody. All right, now is our docket complete?
That's all I have, Your Honor.
Okay, Ms. Gillette, do you have anyone else?
Nope, that's all I have, Your Honor.
Thank you so much, Kim, for helping us out today. We do appreciate it.
Thanks.
Thank
You're welcome. You're welcome. Have a good weekend.
You too.
Good afternoon. This is the Butler County expedited docket for August 15th, 2025. Mr. Patterson, are you ready to go on body Dargatz?
Yes, Your Honor. Well, I should say as ready as I'm going to be.
Okay, and that is 23 TR 3059. If counsel would state their appearances, please.
Jared Regier on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Bonnie Dargatz. Ms. Dargatz does not appear. Judge, this is a case where it's a warrant to show cause. I have been attempting to contact Ms. Dargatz, but have been unsuccessful. So other than that, I don't have an explanation though of why she is not present here today.
She did call in yesterday for the Zoom codes and they were given to her.
Thank you. Motions?
One moment, Your Honor. Your Honor, this is a case where the defendant appears to have been previously given the benefit of a $1,000 professional surety bond. The professional surety bond specifically refers to today's date and time, August 15th, 2025 at 1:30 p.m. Based off the state's understanding, this is a defendant who has a history of failing to appear at least 8 times, including 1 time in this current case. With that being said, the state is recommending a high bond be set in this case. At the very least, $3,000 cash or surety benchmark bond forfeiture. However, if the court determines that a higher bond is appropriate, up to including a no bond hold, the state can prepare paperwork to that effect.
Well, it appears from the journal entries that the defendant appeared in person while she was in custody on August the 4th. And that this hearing date was set at that time. Mr. Patterson was appointed. Under those circumstances, I'm going to issue a bench warrant. I'm not going to set a bond, so no bond at this time based upon the nature of the allegations and history in this case, as well as others. So that we'll anything further on Ms. Dargatz. Hearing nothing further, that matter is adjourned. State of Kansas versus Anastasia de los Santos. Is the defendant present?
She is in custody, Judge, and I would inquire of court and counsel, did you receive my email concerning that case?
I have not seen it. I may have gone through. Was it sent today?
Probably about an hour ago or less.
Yeah, I definitely haven't seen it then. Looking for it.
12:41 p.m. is what it says on my copy. Jared, have you seen it?
It would appear so.
Okay. I do see the competency evaluation and the proposed order. And for the record, the defendant does appear at the Butler County Sheriff's Office. Mr. Regier, any objection to the proposed order for evaluation and treatment?
And, let me clarify just briefly. The order that you have there is not a proposed order so much as it is an order that's already been filed in 25 CR 225. That's a felony case where Judge Crum did issue such an order in that case based upon the competency evaluation done by South Central Mental Health on or about August 8th. I did file a motion to determine competency in this case, expecting that we would just use the same competency evaluation report. I would, however, request that the court authorize a similar order that was done in 25 CR 225 in this case.
Mr. Regier?
Your Honor, it is the state's understanding that in Butler County 25 CR 225, an order for evaluation and treatment to gain competency to stand trial pursuant to KSA 22-3302 was filed with the court as of 2 days ago on August 13th. The order in that case appears to be out of an August 12th, 2025 hearing. If the court is prepared to accept an evaluation proffered by the defense out of another case, then the state will defer to the court as how we should proceed insofar as the motion in this case is concerned.
Do you object to the admission of that document?
The state does not take a position on that issue, Your Honor.
Well, I will accept it, and I will order an order for treatment and to attempt to restore competency, and in the same type of order as in Judge Crum's case. Counsel, I have no objection that runs concurrent, or excuse me, not running concurrent in the way of a sentence, but if wish to have that heard in front of Judge Crum as well, I'm fine with that. But let's go ahead and set it down for another hearing date.
And Judge, that's the difficult part. As you may know, there's a long waiting list for those. Last time, I have somebody currently on the waiting list that was 90 days out probably.
Yes, and at Lawrence State Security Hospital.
Yes.
All right.
And Your Honor, for what it's worth, I'm reviewing the notes in the defendant's felony case. I'm not aware of any subsequent hearings being scheduled at this time, so I'm not sure what the court wishes to do on that front.
And Judge, I think they just took it off docket until they get a report from Larnard saying she's competent.
Well, and that's fine. I'm is that the normal course? Some counties, we go ahead and set it for a hearing, even knowing that it may not, we may not have information, just so it doesn't get lost. But if there's a tickler system here in Butler County that where it catches those once that evaluation is completed, I'm fine with following that procedure as well.
And Judge, typically it is taken off docket, but okay. I am good with either way.
Let's just take it off docket until we get an evaluation for more information. Council can notice the court up and set this matter as soon as we can following that.
And one last request, Your Honor. The order that was prepared in the felony case appears to have been prepared by the county attorney's office. So looks like they have one ready to go. If I could request that the state prepare one in this case too, that would be my preference.
Mr. Regier, any objection?
Your Honor, the order for evaluation and treatment in the felony case does appear to refer to my office in the upper left-hand corner of the page following the cover page. The state does not oppose preparing the order on that front. If that is
very well, so ordered then, and I'll look for that in my queue for signature. So
very good, Your Honor.
Thank you. So that takes care of the De Los Santos case for today. And she can be returned. The next matter is your next case, State of Kansas versus Keith Fuller?
Yes, Judge. And Judge, I will need a brief breakout room with Mr. Fuller. It should be very brief.
Okay, and that case number is 25 CR 364. Is he in custody?
Yes, he is, Your Honor. We're getting him in.
Okay.
Your Honor. To address this early, the state understands there's another case involving the same defendant, 25 TR 1904.
Is that on today's docket?
That is the state's understanding, Your Honor.
and I saw that it was placed on today's docket also, Judge, and that's what I need to talk to him about. I'm not appointed on that other case, but I wanted to go ahead and talk to him about it and maybe dispose of it.
Okay, I see that now. Right, when I didn't see counsel's name on there, I that's why I overlooked that. But it is also 25 TR 1904, and I will, if it hasn't already been done, appoint Mr. Patterson to represent Mr. Fuller on that case as well, and I'll approve the breakout.
Thank you.
I'm going to stay available, counsel, but I'm going to go dark on my screen.
Thank you, Judge.
All right, we're back on the record with counsel and the defendant. Is there some reason why he's wearing sunglasses?
These are my prescription glasses. They're not sunglasses. They're my regular glasses. I have light sensitivity. So
Okay.
I get my glasses through the Eileen Institute.
Thank you. I'll, under those circumstances, they remain. Counsel, are there any announcements at this time?
Yes, Judge. First of all, in 25 CR 364, I would announce to the court that a notice of request for jury trial has been made in that case and been filed. Would ask that it be set for pretrial September 29 and jury trial October 1st.
All right, it'll be set for that on September 29th at 9 a.m. on that docket. I believe Judge Webster covers that. But October 1st for jury. There'll need to be, if there hasn't already, there'll need to be a motion for jury trial as it is a misdemeanor.
And it is on file, Judge.
Oh, thank you. In regards to 25 TR 1904.
Judge, that is a violation of KSA 81525, a regulation concerning controlled access highways, basically a pedestrian on the turnpike. I would tell the court that I have discussed that with my client. He does understand that that is a misdemeanor, but under 8-2116, that is classified as a C misdemeanor. To that C misdemeanor, I've explained to my client it carries up to a maximum of 30 days and up to a maximum of $500. He is going to enter a plea of guilty to that charge, Judge.
All right. Mr. Fuller, have you heard what Mr. Patterson's told me?
Yes, sir.
And if you could stay still for just a moment, please.
I'm trying to have autism.
He does have some mental health issues, Judge.
Okay. Well, please do the best you can then.
I'm trying, sir. I really am.
Thank you.
I do this by drive too.
All right. In regards to that, is that correct? You wish to plead guilty at this time?
Yes, sir.
You understand that with a plea of guilty, you would be waiving your right to a trial?
Yes, sir.
Have you had enough time to discuss this with Mr. Patterson?
Yes, sir. He's my attorney, so that's I have to,
Okay. Has anybody forced or coerced you in some fashion to enter this plea?
No, sir. Not that I know of. I mean, I just asked him a question earlier. That was it.
Okay. Counsel, is there any agreement concerning sentencing recommendations?
We have not discussed those, Judge.
Okay. Very well. Mr. Fuller, as you know, as Mr. Patterson just stated a moment ago, the maximum punishment for that particular unclassified misdemeanor is up to 30 days in the county jail and a fine not to exceed $500. And with those things in mind, do you plead guilty at this time?
Yes, sir.
And on that date, were you walking on an interstate or the turnpike, Kansas Turnpike in Butler County, Kansas, as a pedestrian?
Yes, sir.
The ticket appears that an officer spoke with you and said you needed to exit or be taken to jail, and you indicated you'd go to jail.
Yes, sir.
Okay. I do find that there's a factual basis to find the defendant guilty on that offense. I'll hear recommendations at this time, beginning with the state.
Yes, Your Honor. As a preliminary matter, I'm reviewing the notes from the August 11th first appearance hearing on the traffic matter. I was not the prosecutor at that setting before District Judge Kreml, though my colleague, Ms. Norris, was. based off the notes, there may be certain concerns. One moment, Your Honor.
Right here.
Pursuant to KSA 223302, in this matter, however, if counsel for the defense does not have any concerns, I am in a position to proceed.
Mr. Patterson?
I haven't looked at KSA 82302, so maybe counsel can enlighten both court and I unless maybe the court knows of it.
Forgive me, Your Honor. I was referring to KSA 223302. If I misspoke, I apologize. The title of that statute does appear to refer to the procedure in the event a determination of competency is requested.
I'm not.
But I didn't know the statute number, but yes, I believe that to have been the issue. Mr. Patterson.
Judge, I have spent time with Mr. Fuller at the jail, have discussed cases with him, including the other one. I've discussed them today. I have no concern over his competency. He does have some peculiarities I think the court has noticed, but they don't interfere with his ability to understand what's going on in these cases, in my opinion, Judge.
All right. All of his answers today to me have been appropriate. And in light of Mr. Patterson's statements, I don't find any reason not to proceed. So I'll proceed. Mr. Regier, is there any recommendations for sentence?
Yes, Your Honor. In this matter, the state is prepared to recommend a $100 fine that the court impose court costs, determine an appropriate amount on the issue of attorney's fees. The state would further be recommending a suspended jail sentence of 30 days, subject to a non-reporting probationary period of 6 months.
Thank you. Mr. Patterson?
Judge, I can tell the court my client is not from here. He is from Illinois. We would ask the court to consider whatever fine the court deems appropriate, cost, and consider the attorney fees, but we'd ask court to order time served. He has been in custody or jail since August 9 on that charge.
All right. Thank you. Mr. Fuller, is there any statements you'd like to make before I pronounce sentence?
No, sir. Just, I was just picking up trash. That's all I was doing.
Well, how did you come to be here in Kansas?
I got off the interstate from Missouri. I thought I was still in Missouri, sir. I didn't know I would cross over into Kansas. And then I seen El Dorado, and then something that triggered at the City of Gold. So that's the reason why I got off at El Dorado. Because I was just researching the mounds, and the chief of police in El Dorado, he looked like he was native. So I told him I could make him famous if they found the City of Gold in his city. I thought they were still looking for it. So that's the reason why I was still looking at the mounds and stuff for the City of Gold and the other cities that went with it, that were along the Mississippi. And that's what the research.
I thought that search kind of ended with Cortez.
No, it's still they're still looking. They're still looking for them. They were looking in the Grand Canyon. They never found it in the Grand Canyon. They were looking in the Amazon. They never found it in the Amazon. And they said in the anthropology book that I read, he said that all the lands will be flat. If there's any hills, it'll be mounds. He says that the Midwest is littered with 100,000 mounds.
Well, as interesting as I find this, and I do find it interesting, but I do need to take care of business here. Have you been walking across the United States? What?
Yes, I walk. I walk all over everywhere, sir. I go to rest areas. I pick up trash in rest areas. If I get stuck on the interstate, I'll pick up stuff along the interstate. I do it in Illinois. I do it in Missouri. I do it in Nevada. I did it in California. I did it in Arizona. I did it.
Well, okay.
Everywhere I was driving for Prime semi, I was picking up trash.
Well, and there's a lot of people that hike across Kansas. You just can't do it on certain roadways.
Yeah, I didn't know that, sir. I had no idea.
Well,
I didn't see a sign, so that's the reason why.
Well, they're generally on exits and entrance ramps.
I didn't see one going out of El Dorado, so that's the reason why.
All right,
I was trying to head back to Illinois, but
Any other statement that you want to make before I pronounce sentence?
No, sir. It's just that
All right, I'm going to order credit for time served on this case and find that the sentence is served. So basically from the time of his arrest until now, he gets credit for time served on 25 TR 1904. I've considered a fine. I don't think the interest of justice are going to require a fine. There's been enough punishment in that regard with his incarceration to today's date, which is the 15th. So a week in jail, that's plenty. A little less than a week, but still plenty in my view. I am going to assess court costs and send those to collections. I'm going to waive attorney's fees on this case. Anything further, counsel?
No, Your
Honor.
Is he being held on a bond on the other case that we were setting for jury trial?
He still has a bond in that case, and he'll have to figure out how to make that.
All right. Mr. Fuller, in the event that you make bond, you need to stay in contact with Mr. Patterson and be sure he has a way of contacting you as well.
okay. I tried to contact Mr. Patterson last night or whatnot, but it was,
Well,
just make sure. Just make sure he's going to be here. I just want to make sure.
If you're at the jail, he knows how to get in touch with you. But if you make bond, you need to stay in contact with him as well. Okay.
Yes, sir. Yes, sir.
Very well. With that,
How often do I need to contact him? Once a week or twice a week?
Mr. I would tell you that I've got contact with your wife, and I will stay in contact with her and you if you get out.
Okay.
Okay. Good. Very well. So this matter is adjourned, and he can be returned to his cell until he makes bond.
You can come over here.
9 a.m. on the back there, please.
Yeah.
Okay. Next matter, we can mute that sentence, Mr. Court Security 3.
Yes, Your Honor. I just found out that Miss Dargatz was on the first appearance docket on Zoom, and so they told her to call the clerk's office and get the right Zoom code because obviously they gave her the wrong one.
Well, not necessarily, but she appeared there.
Yes, she was on first appearance docket.
Is she there at Court Security is what I'm asking?
No, she was on Zoom.
Okay, well,
Yeah.
she hasn't been in contact with Mr. Patterson. I'm going to take up other matters with Mr. Patterson first, and if he has time to meet with her, we'll proceed to that. But see, next case I have on my calendar for you, Mr. Patterson, is State versus Kimberly McDuel.
Yes, Your Honor. She's in custody.
Case number 25 CR 361. The counsel state their appearances, please, and if we can get the defendant.
Here we go on behalf of the state.
Your Honor, Darren Patterson here on behalf of Kimberly McDuel. Miss McDuel does appear from the Butler County Detention Facility. Judge, I would announce in this case that I have filed a notice of request for jury trial and would ask that it be set for September 29 for pretrial, October 1 for jury trial.
So ordered. It looks like Judge Crum set bond at $7,500 cash surety and no contact with Casey's in Douglas County or in Douglas, city of Douglas. Does counsel wish to be heard on bond?
Not at this time, Judge.
Very well. Bond will remain as stated. Ms. McDuel, if you make bond, you need to stay in contact with Mr. Patterson. Be sure he has a way of contacting you as well. All right.
And Your Honor.
Okay, they need to unmute it. She's speaking. I can't hear.
If I make bond, am I able to be released?
If you make bond, you're released under the conditions of the bond.
Yes.
Stay in
live
contact.
here in Kansas.
Okay. Stay in contact with me.
I
Okay.
definitely will. Yes.
Yeah.
And Your Honor,
Yes.
this is a defendant who appears to have two other Butler County cases, 25 MR 108 and 25 MR 110. It would appear that waivers of extradition in both those matters were entered within the last week.
Okay.
I'm not on those cases, Judge, but I'm aware of them. And yes, that's going to have to do whatever that does. I don't know.
Is that extradition to Michigan?
To Missouri and one other state, but another judge has taken care of those already.
All right. Those matters can be addressed with that judge. Very well. So this matter is adjourned until the pretrial on September 29th at 9 a.m. And that matter is adjourned. So see, State of Kansas versus Logan Parker.
Mr. Parker.
Yeah. I just go back.
The mail.
Yeah.
All right. Case number is 25 CR 359. Have counsel to state their appearances, please.
Jerry Review on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Logan Parker. Mr. Parker does appear via Zoom audio visual from the Butler County Detention Facility. Judge, this is a case where I have filed a request for jury trial. It has to be set for September 29 pre-trial, October 1 jury trial. In addition to that, Judge, I am needing additional discovery, and the request I am making is that there appears that there should be additional narratives and reports dealing with at the same time that my client was arrested and really intermixed in the same circumstances. There should be additional reports concerning a possible child native care case that I think has relevance to the defense of this case. I am asking that the state provide me all of the reports and narratives concerning that case so that I can be prepared. I will put myself under whatever court order for non-disclosure is necessary, but the two issues are really intermingled. I think it's necessary for me to have that information also.
Mr. Regier?
Your Honor, I have no knowledge as to that. This is a case that appears to have been filed by my colleague, Ms. Norris. So I cannot speak to any of the issues that counsel for the defense is speaking of on the record here today.
All right. Mr. Patterson, if there's a child needed care case, is your client, Mr. Parker, a parent?
He is a parent of that child, Judge. Okay. Yes.
I will authorize Mr. Patterson as an officer of the court may have access to the court file and any sync case that may be involved, as well as reports. Ms. Pierce generally does the child native care cases. So Mr. Regier, you may want to touch base with her, but I can see circumstances being such that reports could be offered in that regard. Obviously, Mr. Patterson will follow his ethical guidelines in regards to, or the ethical guidelines in regards to disclosure on matters that are privileged. If there needs to be a determination prior to trial about various things, we can address it as needed. So, very well. Anything further concerning Mr. Parker?
Nothing further, Judge.
Very well. We'll be adjourned until that September 29th at 9 time. Mr. Parker, if you make bond, please stay in contact with Mr. Patterson.
Yes, sir.
Thank you. Mr. Patterson, do you need a moment to discuss with Bonnie Dargatz?
Judge, my understanding from security was that she was on the Zoom hearing at 1:30 for first appearances. They've instructed her to jump on the Zoom hearing for our case or our docket. I haven't seen her jump. I haven't seen her jump on here yet. So is she on? Jen, is she in the waiting room or anything?
I do have an iPhone in the waiting room that I've asked their name a couple of times.
I'll give you a few minutes to try. If you can put them in a breakout with Mr. Patterson and find out if that's Ms. Dargatz or not.
I will have to admit that person into this court to be able to do that, Your Honor.
Well, that's fine. The individual where it's
that is her, Judge.
okay, I'm going to approve a breakout for Mr. Patterson and Bonnie Dargatz. Ma'am, you'll need to sign on to that or log into that breakout room so you can meet with your attorney. Do we have any pro se defendants?
George Likes at the jail.
Is George Likes present?
Yes, he is, Your Honor. He's the one on the screen.
Okay. This is State of Kansas versus George Likes, case number 24 TR 2231. Counsel would state their appearances, please.
Here we go on behalf of the state.
Right, and you are George Likes, is that correct, sir?
Yes, sir. Yes, Your Honor.
Mr. Likes, I have a notation here that looks like you were in court on August the 8th. And I believe that would have been Judge Satterfield, but I'm not positive. But at any rate, you indicated at that time that you were going to be retaining your own attorney. Have you done that?
No, sir. Well, I talked to Mr. House, but I don't know that.
Well, there's a couple of Mr. Houses that are attorneys that I'm familiar with.
Gary House.
Out of Sedan?
Yes, sir.
I don't see a notation that he's entered an appearance on this case. If I'm missing it, counsel, please correct me.
One moment, Your Honor.
Well, I'm not seeing any entry of appearance. So apparently you haven't hired Mr. House, Mr. Likes. You still are in jail. Are you going to be applying for court-appointed counsel?
Am I going to what?
Apply for court-appointed counsel as you don't have an attorney?
Well, I guess. I don't know. I don't even know what this is about, Your Honor.
Well, you're charged, and I believe you've had a first appearance quite some time ago, but you're charged with driving as an habitual violator.
Habitual violator?
Yes.
I answered for that once when I got out in Greenwood County. They brought me over here, and I bonded on that. It was $5,000 bond, and
well, I don't know. A person can have multiple charges of that from different counties and so forth. So that may be the circumstance. I don't know. But looks like on August 12th, Judge Webster reversed or withdrew the judgment on the bond. And so the bondsman who had posted the bond on this case was not ordered to pay. That was a $5,000 bond in this case, but I don't see that this case has ever been resolved, meaning where you've had a trial or pled guilty or anything to that effect.
Well, if I need to enter a plea, I say no contest. And
well, I want to address this attorney situation first. Do you have the ability to hire an attorney?
yes, sir. I have Mr. House is this a Butler County case?
This is a Butler County case, yes.
I have Mr. House in Greenwood and Elk counties, and I guess I need him in Butler County also.
Was he court appointed in those other counties?
Well, no, he's not court appointed. I retained him. But
well, you're sitting in jail, and I want you to be represented by counsel if you're going to be, if you're wanting counsel, which it sounds like you've got other counties to contend with as well. So speaking with an attorney would probably be a wise decision.
I've got everything but this matter cleaned up, Your Honor.
Okay, what I'm going to do is I'm going to order Mr. Patterson be appointed to represent you in this case. For now, you're more than, if you can hire an attorney and retain Mr. House or any other attorney, that's fine. Then Mr. Patterson will be released from his obligation on this matter. But I want to be sure that you have a right, you speak with an attorney on this case, because if you've got multiple counties, if you say cleaned up, I don't know if that means that you've pled, if you're on probation, or if you've been acquitted. It could mean many things, but this matter is still pending. So I'm going to.
Mr. Patterson will be fine if he's court appointed.
Okay, I'm going to appoint him for now, but you're more than welcome to retain an attorney since that hasn't occurred yet. I'm going to set this matter for my next docket on the expedited docket, which appears to be September the 5th at 1:30.
Can I bond, Your Honor?
And Your Honor, at the appropriate time, the state would request.
I'll hear you now on that. I'll hear you.
Thank you, Your Honor. Your Honor, this is a case where it would appear there have been multiple failures to appear, at least 2 consecutive failures to appear on back in January and June of this year. I'm showing the defendant had been previously given the benefit of 2 bonds, a $2,500 OR bond followed by a $5,000 professional surety bond. Based off of that, the state does consider this defendant a significant flight risk. It would appear that at the hearings in this matter where the defendant has appeared, he had appeared in the same fashion that he does today. So the state is not recommending that the court's prior orders in this matter be overturned.
Mr. Lights, any statement you'd like to make on the bond issue?
In January, I was in jail in Greenwood County, and this matter was addressed here in Butler, and the sheriff sent me over here with one of his deputies, and it was addressed then, and I was bonded out right here in Butler County, and it was set then for 6/11, and I got mixed up, and I thought it was 5/11, and I called everybody I could to see if I was missing a hearing on 5/11, and I was a month early. It was 6/11, and they told me I wasn't missing anything on 5/11, and they didn't see anything pending. So And then I was told there was a bench warrant, and I turned myself in.
You seem to have a hard time making it to court, sir, and keeping your court appearances straight. I'm going to set bond at $10,000 cash or surety because of the failure to appears. And so if you make it, you bet whoever you're bonding you out, you need to have a discussion with them about how they're going to be sure that you're at court. And I'm not going to permit you to appear via Zoom unless you're at court security. You have to show up at the courthouse for any future hearings on this matter.
Yes, sir. And here in Butler County.
Yes, sir. Yes. Butler County. So if you make bond, then you need to contact Mr. Patterson or the attorney of your choosing. But your next hearing is going to be September 5th at 1:30, and you are to be at the courthouse to conduct that hearing. Understood?
Yes, sir.
Very good. That this matter is adjourned. Mr. Patterson, are you ready to proceed with the Dargatz case?
Yes, Your Honor.
Okay, I'm recalling 23 TR 3059. If counsel at State of Kansas versus Bonnie Dargatz, counsel would state their appearances, please.
Jerry Riggey on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Bonnie Dargatz, who does appear personally via Zoom audio visual. Judge, as the court knows, this was called just briefly a little bit ago. The court did issue bond for a bench warrant, no bond hold. Would ask the court to consider setting aside that order, allowing us to proceed with the warrant to show cause.
Mr. McGeer, any objection?
Your Honor, the state does not consider itself in a position to advise the court to overturn its own orders, so the state will defer to the court on that issue.
I'm going to recall that warrant. We'll take up the issue that we're to address today at 1:30. Are there any announcements on that front?
Yes, Your Honor. There are two violations listed on this warrant to show cause. First, that she has failed to report to court services as ordered by the court. Second, that she has failed to pay on her cost, fines, fees. She does waive hearing. She does acknowledge those violations and does stipulate that they are true.
Ms. Dargatz, have you heard what Mr. Patterson has told me?
Yes.
And is that correct? You're waiving your right to a hearing on whether or not you violated your bond?
Yes, sir.
You understand that you're entitled to a hearing before the court where the state would have the burden of showing by a preponderance of the evidence that you violated the conditions of your bond, of your probation?
Yes.
Okay. And has anybody coerced you to enter in to this admission and waiving your hearing?
No, sir.
Are you under the influence of any medications or intoxicants at this time?
No, sir.
Very well. I find that the plea or the waiver is knowingly and voluntarily entered with the advice of good counsel as well as the stipulation. And I do find that the defendant has violated the terms of her probation as indicated. I'll hear recommendations as to how to proceed at this time, beginning with the state.
One moment, Your Honor. Your Honor, this is a case where, pursuant to the journal entry of misdemeanor conviction and sentencing from February 16th of 2024, that the court did order a 6-month underlying jail sentence with respect to count 1 and a 6-month underlying jail sentence with respect to count 2, that those should run consecutive, but grant the defendant a reporting probationary period of 12 months. In the request for revocation filed with the court in June of 2024, it would appear to suggest that no payments have been made. I have reviewed the the case summary public portal access for this matter, it would appear that as of today's date, there have not been any payments made on this matter. It would also, if given the fact that the defendant has stipulated to both violations as set forth in the request for revocation, the state is recommending revocation of this matter.
Very well, Mr. Patterson.
Judge, before I make my argument to the court, I do have one question that maybe the court can help me clear up. In my notes on my file, I have that the charges ran concurrent. Did the court have notes from the date of sentencing, February 16, as to whether it was consecutive or concurrent?
In my notes, I show concurrent.
I'm looking at that, and it does show them concurrent in the notes. The journal entry that was signed by Judge Webster. It would appear that was February the 9th, but it was for that 16th of February. And looking at the journal entry does not reflect the judge who was assigned to it. So since
Judge, this was your
Webster signed that, probably because it was originally assigned to her. But I took the plea, and the notes reflect running concurrent, and that's generally what I do on a case such as that with those type of counts. So I'm thinking it was actually concurrent.
And Judge, I would agree. I would just ask the court to allow the journal entry to be not protunct or modified to actually show what the court had ordered, which is concurrent sentencing. So that's a 6-month controlling sentence.
And Your Honor, what I would tell the court is I've reviewed my notes from the February 16, 2024 date. I do acknowledge I was not the prosecutor at that particular setting. However, it would appear based off my notes that the court did order that all counts should run consecutive. And that does appear to be reflected approximately 3/4 of the way down on the first page of the journal entry.
Well,
respectfully, I just think the county attorney's office notes are off there, Judge.
Well, and to be honest, I don't have a present day recollection of that. Like I said, typically on a driving offenses such as these that occurred at the same time, I would make those run concurrently, particularly in light of a 6-month sentence. So I'm going to find it, unless if there's a challenge later on, if counsel wants to review the video that would have been made, and if indeed I made those ordered to be consecutive, please address it. But I'm, as the court notes, appear to be concurrent, as well as Mr. Patterson, and just what my general sentencing would be. I'm going to find at this time that I said it as concurrent, but yeah, I don't have a present recollection of it. So if the video reflects differently, then we can readdress this. But I'm going to treat this as being concurrent at this time.
Thank you, Judge. As to arguments in this case, Judge, I would tell a court that have discussed it with my client. I can tell a court she has stipulated to these violations, acknowledges they are true. She has told me that when she was released after plea and sentencing in this case and released, she was homeless, that she was homeless for some time and had a tough time trying to get situated to where she could keep track of her day-to-day life, I think, in general. That currently she does live in Winfield. She does have family support, living with her son, so that at this time she had stated that she can make sure that she has ability to report and do the things that she is required to do. She's also on disability and has told me that only within the past few months has her disability been approved, and she's actually starting to get funds coming in so that she was not able to make payments until recently, although there hasn't been any made yet. She plans to. So, Judge, in the end, we're asking the court to consider her homelessness and consider her disability, allow her to continue on probation in this case. Thank you.
Ms. Dargatz, is there any statement that you'd like to make on this matter?
No, Your Honor.
And Judge, I apologize. One more thing I think the court might need to know or want to know. I did get jail time credit so that I could figure out and make sure where she was at. On this case, the jail sent me that she has 21 days credit. Part of that is from August 1st, 2025 to August 10, 2025, 9 days at that time when she was arrested on this warrant to show cause. Thank you.
And she was granted 12 days of jail credit at the time of sentencing.
Yes, Judge.
Well, as I've stated, I don't specifically recall this particular sentencing, but my practice is when I'm placing somebody on probation is to explain to a person what they need to do, and that if they choose not to comply with the probation, then they're just telling me that they'd rather do their time. Ms. Dargatz, it doesn't reflect that you ever reported anywhere, by phone or in person, anytime. So I'm going to revoke you at this time. Where are you currently at?
I'm in Winfield, Kansas.
All right. I'm going to give you till do you have transportation?
I do not.
I'm going to order that you go and report to the sheriff's office there in Winfield. There, it's Cowley County, but you can surrender yourself to law enforcement in regards to this. But I'm going to issue a warrant for you so that you can be taken into custody to serve your sentence. I normally have these hearings in order to appear in person, but I don't see any notations to that order in reviewing this. So probation is revoked.
And Your Honor, in light of the court's finding on the record today, does the court wish the journal entry to reflect a 6-month sentence?
Well, yes, I'm not modifying the sentence. It was a 6 months and it runs concurrent. It looks like there was a later notation that the court cost may have been inappropriately applied. The court cost should be $108, not $158, as this was a traffic case and not it's a misdemeanor, but it goes as a traffic case. So the court cost should reflect $108, not $158, if that hasn't been corrected yet. So
if the court wishes my office to authorizes my office to file an order concerning the cost, my office will prepare such an order, Your Honor.
Please do. Yes, that's the order. Anything further on this matter today? Now, Ms. Dargatz, you can help yourself by cooperating and getting yourself turned in. And you may be able to discuss this with Mr. Patterson, and we can I may consider a motion at a later date, but if you just disappear, that'll be considered as well.
Right. Okay.
On this matter.
Thank you.
And does the clerk have looks like Mr. Bosley?
No, Your Honor, he is not here.
All right. This is stated, and Mr. Patterson, do you have any other matters?
Judge, I do not. If I could be excused, please.
Yes, you are. Thank you. Thank you for your appearances today.
Thank you, Judge. Have a good weekend.
All right. Mr. Regier, any other matters?
Not at this time, Your Honor.
Thank you. We're adjourned.